Happy Friday, everybody. Hello, true crime lovelies. I'm going to thank the members and I'll see you on the other side. I did not think he was going to rule on this until after they tried to seat a jury, just based on what he said. But I do know that last week the defense filed an addendum to their motion for change of venue. I couldn't see it, but I saw that there was a filing on there. Anyway, let's see. So, order on defendant's motion for change of venue. This cause comes before the court, filed January 14th. Court having considered the motion, accompanying memorandum of law and affidavits, reviewed the record and accompanying exhibits, held an evidentiary hearing, and being otherwise fully advised, hereby finds. So I'm not going to go through the background. We all know she's accused of murdering her son-in-law. So the state, let me just do, nearly 3 months later, she filed an accompanying memorandum of law in support of her motion, along with multiple exhibits. Not 3 months later. And he's saying it was prompted by a temporary unsealing of an in-camera transcript, i.e. the Rob Adelson transcript. I think there might have been one before that. I feel like Brother Counsel had one. It might be this one, though. But I know Brother Counsel he was quick and put up the video, and then the motion was taken down. Okay, sorry. Am I in your way? Okay, I'll pick you up. The state opposes defendant's request at this juncture, insisting that the only way to determine whether an impartial jury can be impaneled in Leon County is by first attempting to impanel an impartial jury. And we all remember that epic cross that Georgia did with their quote-unquote expert, their Kohlberger expert. Is it Kohlberger? The one who just pleaded guilty. Analysis. To prevail on her motion, defendant has the burden to demonstrate that the setting of the trial is inherently prejudicial because of the general atmosphere and state of mind of the inhabitants in the community, Manning v. State. More specifically, the test for determining... Yeah? Are you helping me out? Okay. Justice. I feel like it's about to go off the rails. Let's focus in. Deep breath. The test for determining whether to grant a change of venue is whether the inhabitants of a community are so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely on the evidence presented in the courtroom, Griffin v. State. Florida Supreme Court explained in Manning that a trial court could determine whether to change the venue for a trial prior to commencement of the jury selection, or a trial court may withhold making the determination until an attempt is made to obtain impartial jurors to try the cause. So that's what I was thinking we were going with. As often occurs with the passage of time.
Oh no, he did it.
Oh no.
Oh no, keep back.
Okay.
Keep back.
As often occurs with the passage of time, legal precedent on a subject evolves.
Mama.
Yes. So remember, Donna's defense came in with citations from what did we say? The 50s? The most recent ruling from the Florida Supreme Court regarding a change of venue requires a trial court to make a two-pronged analysis. Trial courts are to evaluate, 1, the extent and nature of any pretrial publicity, and 2, the difficulty encountered in actually selecting a jury. Smith v. State, citing Griffin v. State. Emphasis added. There are various factors. Okay, let's go through this. One of those factors, whether the defendant has exhausted all preemptory challenges, even necessitates proceeding to prong two. The critical inquiry for prong two is whether any difficulty encountered in selecting a jury. So we haven't gotten that far. So we haven't met either one of those prongs. Reflective of pervasive community bias against the defendant, which so infected the jury selection process that it was impossible to seat an impartial jury in the county where the trial was held. Quote, Rolling v. State. Both the extent and nature of the pre-trial publicity and the difficulty actually encountered in selecting a jury are critical factors. So I think they demonstrated, or partially demonstrated, to be fair, with the expert. Okay, honey. Can I rock you?
Yeah.
Okay. Okay. So I think their expert partially demonstrated that, except there were no geolocations on it, right? So we have no data to say that it was specifically in Tallahassee. They showed what evidence was kind of out there, but we talked about this. Like, we're on YouTube. It's worldwide. It's not like just honing in on Tallahassee. So they had no quantitative or qualitative, in my opinion, data to show that the specific people in Tallahassee were tainted. And I know they showed some of Miami, which they never explain why. I mean, we know that's where Donna's from, but they never, like, again, no geotags to say less people in Miami have been infected with knowledge than Tallahassee, right? So it's a little strange. And they do it by percentages. So it doesn't matter that Tallahassee is smaller than Miami because we're going by percentages. So that data was just flawed anyway. And it was combined with Donna and Charlie, and we could not separate out Donna. He could have done a pivot, but he was like, he didn't want to do it on the spot. But I mean, that should have been readily available. Someone was going to ask, what about just Donna? Okay, so defendant would have this court reject these binding precedents and turn this into a one-prong analysis. The court declines to accept this invitation, which is fair, right? Because if he ruled that way, there is no precedent, but the state does not have an appeal right. In this, Donna could go back and appeal, like, to an appellate. I mean, she's already done it, trying to get the judge recused. So I think this is fair. Although it is undisputed that this case contains extensive pretrial publicity, undisputed. Pretrial publicity is normal and expected in certain kinds of cases. And that fact standing alone will not require a change of venue. Griffin. Therefore, Section 91003, Florida statutes, and Smith, along with its related precedents, compel an approach that includes voir dire of the inhabitants. So the people of Tallahassee need to be voir dired first, where the crime is alleged to have been committed. That's got to be the first step. You can't just jump out. And I think, like in the Kohlberger case, is it Kohlberger or am I hungry? Or whatever. The Idaho case, there was also an infrastructure issue, right? They moved it, part of it, because they didn't have the town didn't have the infrastructure to support the amount of traffic that was going to happen, because not just traffic, but the people coming in, right? Not just car traffic, but the amount of people coming in, the size of the courthouse, the security that was needed, etc. You guys know what I mean when I say infrastructure, right? The second prong of the analysis requires the trial court to examine the extent of difficulty in actually selecting an impartial jury at voir dire. And that's also where they would get their challenges, right? We remember Charlie talking about his strikes on the phone, and like he was striking for people that shouldn't. He felt like he was striking for people that he could not allow in the jury, and the state was striking for people that would be in his favor. But that's where you get your say of like, oh, I don't think that person would be a good juror for me. Defendant's approach also, and he paid $1 million for that. Defendant's approach also ignores the long-standing principle that jurors with prior knowledge or even preconceived opinions as to the guilt of the accused can nevertheless serve on a jury if they can set aside their beliefs and render a verdict based solely on the evidence presented at trial, right? So we talk about this all the time. Just because they've heard of it or just because initially they thought someone was guilty does not preclude them. They have to say whether or not they can set those preconceived opinions aside. And if they can, and like hear the evidence for what it is, then they are eligible to be seated on the jury. So it's not like you have to have never heard of it. So just the fact of publicity alone is not enough. Because you could have heard of it and not formed an opinion at all, or been like, oh, that's interesting, or like, oh, she sounds guilty. But then when asked, like, once you hear all the evidence, the facts, would you be able to set that aside? And some people can. Some people can. They're honest. Some people just don't want to be on a jury. They'll say anything. To hold that the mere existence of any preconceived notion as to guilt or innocence. Okay, he's just quoting that. I'm going to skip down here. You guys, if you want to read it, you'll be able to come back and stop and pause. As a result, it is possible to impanel a jury comprising persons who can be relied upon to decide the case based upon the evidence. And it's sort of parenthetical, the evidence presented at trial, not what they heard on YouTube. Okay. And not be influenced by knowledge gained from sources outside the courtroom. Okay, I jumped the gun. Then a denial of change of venue is proper. Defendant has provided no legal basis to forego the essential task of asking prospective jurors whether they can be impartial, right? So we got to do at least voir dire. Despite any potential, don't do that, extrinsic knowledge about this case, along with other vital questions. Furthermore, it's always good when you get a furthermore. The court finds the hearing evidence does not demonstrate that the extent and nature of pretrial publicity is so pervasive that attempting to seat a jury would be futile. Yeah. So you paid all that money for that expert and got wah, wah, wah. Can you say that? Wah, wah, wah. Wah, wah, wah. Yes. Wah, wah. The court is mindful. Conclusion. The court is, sir, can you get your monster truck off my keyboard, sir? Hold on. Conclusion. The court is mindful that nearly 70 years ago, the Florida Supreme Court declared that every trial court, in considering a motion for change of venue, must liberally resolve in favor of the defendant any doubt as to the ability of the state to furnish a defendant a trial by fair and yes. Yeah. By a fair and impartial jury. So that 1959 quote that they were relating on, I think Judge Everett said it was like his father's age, is no bueno. However, the defendant has not provided a sufficient legal or evidentiary basis for bypassing the Florida Supreme Court's two-pronged analysis regarding a change of venue. You did not meet the threshold, ma'am. Lump sum of traditional media coverage the defendant cites in her motion draws factual information from court records and proceedings. Do you want some lemonade? Do you want lemonade? Yeah. Okay. Defendant has not shown how the local reporting that comprises her evidentiary hearing exhibits is any different from cases where a change in venue was not required. See Foster v. State. Voir dire is appropriate for excluding prospective jurors who have been otherwise exposed to any inflammatory content. Also, can you imagine if he waived voir dire and let them do it? Like, he would be setting a weird precedent, right? Like, that would be carte blanche for too many criminals in Florida. Moving jury selection from Leon County, based on the current record before the court, would reject the capability of all prospective jurors to set aside any preconceived notions or opinions and assure that their verdict will be based solely on the evidence presented. Okay. It would also discard the quote firmly embedded principle of criminal jurisprudence that a person of a crime must, as a general rule, be tried in the community where the alleged crime took place. And that's fair for the community that they have, like, those are, I mean, the community is who was impacted by Dan Markel's murder. It's fair that they be able to sit in judgment of the person accused of murdering him. Without first assessing a critical factor in the analysis for changing a venue, Carter. This also does not mean that defendant will be unable to raise the issue of venue following voir dire. So let's get to voir dire. If there is an actual issue, then we've met the two prongs, right? She'll have had her challenges, although, yeah, she'll have had her challenges. I don't know, though. Can you tell if your challenges failed or not? But I mean, I don't know. That's kind of nebulous. I don't think her case is strong enough to win. So it doesn't, like, how do you determine? I mean, I guess they could complain and say, we ran out of challenges. I'm not sure. What do you guys think? It simply means it is too soon to determine whether a change of venue is justified. So he's not saying no, but he's saying we're going to at least try and seat this jury. Similarly, the court declines to grant additional, I don't know, additional preemptory challenges after she has exhausted the number afforded to her by law. She's asking for all kind of favors. So not only do they want it moved, but if we have challenges, we need extra because our client is extra guilty. We need to get rid of some other people. A trial court in its discretion may grant additional preemptory challenges. There is a right under Florida law to a certain number of preemptory challenges, but there is no right or entitlement to additional preemptory challenges. Uh-oh, Donna's losing her entitlement. No entitlement for you here, sis. Beyond those established in section 91308. No what? No. So order on a judge, the ruling is reserved on the motion for change of venue. Defendant may renew her motion following an attempt to actually select the jury. A change of venue will not be granted unless defendant can demonstrate both prongs of the applicable Florida Supreme Court test. It is further ordered in a judge that ruling is reserved. That ruling is reserved.
Oh no.
On defendant's request for additional preemptory challenges until after she has exhausted the number afforded by law. So we're going to try to seat it in Leon County and you don't get any extra challenges. We're going to just try it the old-fashioned way first. And then if you're able to prove that that didn't work or it proves out just by the... So I just think, yeah, I'm not surprised. Yeah. So yeah, it's reserved. But he's saying we're going to at least attempt to seat a jury, which is what the state asked for, which just seems to make sense because the 1959 citation that they had has had two subsequent rulings that negate it. Thanks for hanging out. I appreciate your patience, and I will talk to you later. Do you want to say toodles?
Yeah.
You got to do this. Toodles.
Yeah.
Bye, guys.